Yes, welcome to the No State Project Live for January 15th, 2020. Glad to be with you here. Hope everyone starts filing in. Let's see, I don't know how you got that fast, but someone's saying, what's the number? Says when I called just now, new number. Yeah, as I mentioned on the show last week, the 218 number is now defunct. I did not pay attention to the emails from the Free Conference Pro because I thought it was just someone phishing. It didn't look like a legitimate email. So I lost my number. It's just like years ago. I used to have adventuresinlegalland.com. And there was a lapse. I didn't get an email. I didn't renew the name, and it was immediately bought out by some Chinese company for whatever reason. It's not like it was a big website, so we know that who was on the losing end, was really on the losing end of that one. I do apologize for that. Probably going to need the mute button here because, and I apologize again. I did not get the new video up with the success story because I have been pretty sick all week. So, yeah. So you're going to have to bear with me there. I tried getting another caller line today, but freeconferencepro.com worked so well. I mean, it was flawless. I mean, other than having to put in a passcode, you just call the number, you get through. So there was another one, but there were two stages. You got to make the call. You got to plug in what the conference is. Then you've got to put the PIN number. So it's 3 steps. And I just figured, I'm not going to do that to people. If you want to join the show, I will give the number out. This is for today. I should have this squared away because I can use Free Conference Pro only on Google Chrome. Why you would just limit it to one single browser? I could see not including Explorer. I get that. But why you would have it with just Google, I don't know. Let's just cut Firefox out. Maybe because it doesn't report as much. I don't know. But if you want to join me on the show, you can. That's the thing. It's. I'm going to keep everything muted up so you can call during the show, but I'll only be able to get one call at a time, as far as I know. So that's the way we're going to have to run it today when I take calls. But I got a few things to get to first. So write this down. Maybe somebody put it into here. I'll just type the damn thing in. It's 602-635-1974. And there is no passcode for that. That's the number. And I'll keep it muted up, and I'll check to see here if I've got a caller. I'll be able to do that during this show. And so if we've got people who want to call in today, that's how you do it. And you can still use Skype at Frank Rizzo 3. So let's say Frank Rizzo 3 is that's the Skype. So that's the two ways to reach the show today if you want to get into this there show. Man, I hope I don't sound too bad and I sound too sick. I was really sick yesterday. I had no IRS call. I tried. I couldn't stop coughing long enough and just didn't work out. So I did other things, but I wasn't on the phone. So if there is somebody who wants to join, it's 602. See, I made this mistake before trying to give out. I started giving a 602 number, but now I got to remember no 218. It's 602-635-1974. 1974. That gets you into. There is no queue today. All right. I wouldn't say this is a typical tech issue, but we'll get through it. But I had some good news I wanted to report on and give a little bit and expand on what we're doing. A shout out to, of course, John in Austin for the good job that he did on his own with the IRS. Have them openly admit. This is what I talk about all the time. Have them admit what their foundational claim is. Why are you doing this? What is the foundational legal claim? They tell you what it is, or they agree, or they affirm that what we say in the leading question is the way they're operating. Then you start going. Then you start with the questions, and you just want the facts. You want to know if the facts really are getting to, can they prove that the claim is true? And so John was able to get into a bit. No. So what they like to do is kick the can. Well, we're not the right department. Isn't your department the one making the determination? It's like today, talking to the SFR unit, the substitute for return unit. If you don't file a return, they'll threaten to file one for you. Even if you provide the information that should be abated. They're the ones making the determinations, but it's always another department. See, they insist that these claims are true. Oh, you have an obligation. Can you prove it? Do you have facts to prove that? Oh, that we're not the right department. So they're very good at taking responsibility when it comes to accusing you and willing to kill you because they believe that claim is true. So true, it couldn't even possibly be wrong. Any challenge is automatically frivolous. But when you start challenging them to prove their assertion, oh, that's not my, you got the wrong department. Got the wrong department. Yeah. Yeah. Oh, so yeah, you got to memorize. Well, you don't. You're sitting at a computer. There's nothing to memorize. You copy and paste the damn thing. See, again, that's also why I think I'm not going to have 3 different numbers for people to do just to get into the show. Not going to do it today. I will do what I can, and if I have to be able to use my beloved Free Conference Pro, because there isn't another service that does that, I will have to bite the bullet. And I will have to fire this computer up on Windows. Yeah, Brian Allen saying wrong department every time. No, so you find out first that. So I had some pretty good calls today. I'm surprised I can even do the show after how long now. We had the longest call of the year so far. And I hope that record stands. It was well over an hour straight. Well, we were on hold a lot, to the IRS. And so what we were able to get out of these 2 calls today, and it took some calls just to get to this. We were seeking, and what I always recommend doing is getting a stay. And not only did I get 1 stay of the proceedings where it's not going to escalate, I got 2. That might be a first. We got 2 stays. Now, one's only 4 weeks, but the computer process has been stopped. And that is huge. That's huge. Huge. Just in my experience, that is paramount to getting these things tossed out. You've got to stop it from escalating. And I don't think that matters whether you're working with me or anyone else. You're doing a traditional amount. I'm just going to argue the amount. You got to stop the computer from spitting out form letters. Got to stop the escalation. You have to. If you don't do that with every form letter, with every step in the escalation, it's getting monumentally more difficult for you to get this thing tossed out. And again, it doesn't matter how you're going about it. You're doing it from a factual standpoint. You're doing it from a legal standpoint. You're just talking about the amounts. Got to get that. And so something that I found out, they upgrade their computers every year. We're right in the heart of that. So when we called on Monday, we had a really good agent. And we walked him through the process. And he wasn't the first one. We'd already done this a few times. We already knew what the foundational claim was. They all admitted to it. We then asked them for the facts. Well, first we found out what department we were in. Then we determined Is this the right department to deal with this form letter? Yep. Okay. And if it's an erroneous form letter, this department's the one to handle that and maybe abate it. Yep. All right. Is Spencer Morgan, are you the guitar player that we've jammed before? So let me know this if that's the same Spencer. If it is the same Spencer, quite a lead guitarist there. Okay, so we found out we had the right department. We knew we found out which department we were with. We were, in, because you're just because you call the number on the form letter doesn't mean you're going to get the right department. And then we determined that and had to agree that it's the right department to abate an erroneous form letter that had been sent. And then we get them to admit what the foundational legal claim was. And then we ask them for the facts. And of course, they don't have it. They want to kick the can. But you can go back. But you said, I asked if this was the right department to handle an erroneous, let's say 2566 or CP 59. And you said it was. Well, they'll come up with every. So what I like to do, and I've mentioned this before, and when we got new listeners, which is always great, they know it's very difficult to communicate with them. And we've got them kicking the can. So that's when I start floating the idea of, well, we got two things we want to do here. We want to, yay, Spencer. Yep. Yeah, that was, I need to do more blues jams. That was fun. That was fun. We need to do that. I need to do that again. It's been a long time it's been probably 2 months since I've jammed with somebody. Anyway, okay, so the two things that we're looking for is we want to stay and we want an agent with direct contact information to be assigned. Now, Section 3705 of the Restructuring and Reform Act of 1998 obligates them statutorily that when we request an agent to be assigned, that they are supposed to assign an agent and provide us with direct contact information so that we're not going through the switchboard. So my position is, look, since we already know it's extremely difficult just to get to this point, it takes a lot of time. And you're sending us to another department. They're probably going to send us to another department while the IRS is trying to figure out what the right department is. And even if they're going to assign an agent, could you please stop the form letters from coming out? That's actually the way they understand it. If you say stay the process, they don't know what the hell you're talking about. That's not the way they speak. But if you tell them, can you stop the form letters from coming out? Now they know what you're talking. Oh, I can push that button. Now, when we did this on Monday, the agent was really open to giving us the stay and stopping the form letters. And that's when he had to give us the bad news. And the bad news was the IRS was upgrading their computer system still. And in the phrase that they used was, it was a dead cycle. I've got someone who's calling, so I'm going to leave you on hold. I'm going to leave you muted up there. So we have a one man or woman queue. So just hold tight. I got to finish this. So, a dead cycle. So he said, call back on Wednesday. Well, he said, call back on Tuesday, but I couldn't make calls yesterday. So we called back this morning. Oh, before that, this is very important. See, I'm still a little fuzzy. This is very, very important. So write this down. Memorize this, not the phone number. If it's possible, you have them put a notation on the account that a stay or whatever it is that you're looking to do, have them put that a notification on the account. So I had the agent do that. So I can't just leave it here. I've got an agent who wants to put a stay on the process to stop Ogden or Austin from just spitting out these formulas. He's going to stop the computer. You can't leave it there. You can't do it. If I had left it there, I probably would still be kicking myself. Okay. Well, obviously, I can get more people. Okay. Let's hold up on the calls. I want to make sure I get them all in order. I got somebody from New Hampshire that's going to have to wait because you're second. I got to figure out how to do this in the middle. Okay, so anyway, why is that important? Because if we call back and there's nothing in there, I have to go through the process all over again, and I may not have somebody who's open to giving me a stay. So I floated the suggestion, hey, could you put a notification on the account so when we call back, they can just see that and they can just, in minimal time, they could just push the button and stop the process. Yeah, I could do that. So we were able to get off the line fairly confident that, one, they're not going to assign the agent because they never do. But fairly confident that if he put that into the record, which he sounded like a decent guy, that when we called back, just like we did today, the agent looked at the account. You have to verify who you are so you can get into the account. It's only 4 things: name, social, date of birth, current mailing address. That's it. You've verified your identity. Don't listen to anybody that says anything else. Anyway, so once we were there, he just had to get into the account, and he saw the note from the agent on Monday. So what did he do? He said, I can't help you today because we're in a dead cycle. No. So I forgot to unmute myself. So thanks for letting me know. I guess for the podcast, I can get that. All right. All right. All right. Anybody calling, I've got you. You just have to hold tight. I got you muted up. Let me just finish my IRS stuff. So I have to finish again. So the agent saw the notification on there, was very willing to go ahead and do that, but gave us the bad news in that the computer system was down. So he went to put us on hold for 5 to 7 minutes, and he comes back and he says, first thing out of the gate, he says, well, thanks for waiting. I was able to put the hold on. So parts of our computer system are still down, but I was able to do that. And I'm like, oh, yes. That's all I care about right now anyway. As long as I can get that stay, man, they can shuffle it around to every department 10 times over. I don't take as long as you want, as long as the matter isn't escalating. I don't give a damn. We've met the objective. We still make the request to have the agent assigned with direct contact information. Of course, we're going to do that. But the important thing is we got the stay. And on the next call, right after that, my gosh, this was over an hour long. I was only able to get a 4-week stay, but that gives us some time. And it's much easier to can get a stay extended, let's say for 90 days or whatever it is, once we already had the process stopped. I guess it's one of these things they don't like to change. If a new agent comes into, and you get them on the phone and they see that there's a hold on the account, they're more inclined to keep that hold on the account as opposed to when there's no hold on it, they don't like to do that. So now I've got 2 days, 2 calls in a row. These were consecutive where we were able to get a stay of the process, the computer process. And yet, half the time, you guys, I don't have a queue right now. You can't. I'm going to take calls one at a time. We've got to do them consecutive. I can't just get a line of calls. So just bear with me here. I just want to finish in a minute here about my IRS stuff. So you kind of threw me on that. I guess that's where we'll leave with the. I was just saying that they're loath to upset the apple cart, but we got the stays, and yeah, that's it. So we almost inevitably will get, let's say, half the time, or less. Well, maybe say two-thirds of the time this doesn't happen. So 33% of the time, we'll come across an agent who's a real jerk, and they say that they can't put a stay. They say that you cannot stop the computer process. Well, that's not true. I've done it for years, decades. I can't believe I can say that, but I've done it for decades. Okay. I've done it many, many times, and we did it just two more times today. Just sometimes you get these agents that take things personal. And even if you spent an hour on the line, if you get an agent who refuses to do a stay, don't give them too much of a hard time, because they could put something negative into the account. Just call and talk to another agent. That's what we did. I unmuted myself that time. Yeah. So I'm glad that we were able to get that. I know, because I've been sick, I did not get the success story thing. I will get that posted hopefully in the next couple of days. Just hang tight. But so far, we got a traffic ticket in New York thrown out this year, and I got 2 stays with the IRS. So that's pretty damn good. So what we're going to do here, we'll see how this works out going directly from Skype. We've got area code 603. You're live on the No State Project. What's your name? Where are you calling from?
Hi, it's Mikey from a few months ago now with the New Jersey ticket.
Well, Mike, you got good news for me.
Well, good news in the sense that I was better prepared this time than for a case a few years ago, but hold on, there's a car coming by. But I had the trial last night, and I asked the typical things. I objected where I could, and I told you in the email about the judge said, I'm taking judicial notice that the laws apply. And you said you replied in the email that I should have objected to that, but you can prepare for everything and they throw something new at you.
Yeah. However, I got to throw this out. Okay. So don't take offense to this. How many times have I said that you're going to be objecting to pretty much everything?
A lot.
I get you're in the heat of the moment. You're not a professional litigator. I get it. But for those listening, I think I even mentioned it on the last show, object often, right? That's a big one, because almost everything the judge and prosecutor are going to do is going to be objectionable because it's not fair. So when the judge does that under the rules of judicial notice, well, first of all, I don't even know in New Jersey if they can take judicial notice of legal arguments. Judicial notice is only, unless you're in California, for example, where they can take judicial notice of the law, not a legal argument, but they can take judicial notice of the law, what the law says, not a legal argument, which is what the judge did here. Also, judicial notice, unless you're in California and some very rare other places, judicial notice is only for adjudicative facts. So that right there, you should be obvious to everyone listening what you can object to here. That's not an adjudicative fact, is it? And you put in the form of a leading question like that.
Yeah, I think I forgot the objection. That's not fair. That that's a standard one to fall back on.
Okay.
But I did object on a lot of things. I asked a lot of the questions. Should the prosecutor objected here and there. The judge actually a few times said no. Let him ask the question.
Nice.
So even if he sometimes he would sustain it, sometimes he wouldn't.
Can you give me an example?
What was that again?
I'm sorry. Can you give me an example of an objection that the prosecutor had overruled and one that was sustained?
I don't have the notes in front of me, but
okay.
Basically, anything that was about jurisdiction, they quickly objected and sustained. But anything that was kind of like tangentially different, I guess you could say, he said no. Let him ask that.
Okay. Well, on as far as before the witness was put on the stand, did you object to them being put on there on grounds that the prosecution did not have? Yeah. Did you have proof?
Yeah.
Okay.
Yeah. I objected to that, and he said, "We'll get to that." It's always "we'll get to that." It's like you say, "Oh, it's a trial issue," and then in the trial they say, "Oh, it was a pre-trial issue."
They did that to you?
So, no, they didn't say that, but he did say at the beginning of the trial when I objected to the witness, I objected, and he said, "We'll get to that. We'll get to that issue at the end."
Okay.
And,
yeah.
How many times can you object? I can keep objecting, and then you end up. I guess you end up against contempt.
Well, we object once. We object one time. You don't keep pushing the issue. Yeah. You make your objection. It's a part of the record, and you got to move on.
Yeah. It's like there were different questions that touched on jurisdiction or the laws applying again, and as soon as I started asking, the judge even objected. He's like, "I'm going to object," and I guess that was the part where I should have objected back and said, "Whose side are you on?"
Yeah, the judge can make a ruling, but I don't think it's the judge. The judge can do a lot, obviously, but make an objection on behalf of the prosecution. That's that. Yeah, I'm going to say that's evidence, strong evidence of bias there. Well, when it comes to the cross-examination, because I don't remember seeing an email about that. The cross-examination, did you ask the standard questions on cross-examination where you ask him to confirm that he made that legal claim at the stop, and then you ask for the facts? Did you determine on your own that just because I was physically in New York that the laws applied and gave you jurisdiction? Did you go through those questions?
Yeah, I asked all that. Some of them he answered, some of them the prosecutor objected. So sometimes he would say yes, and he gave contradictory things. Like I said, "Are you here voluntarily?" Yes. "Were you subpoenaed?" Yes. "So did you choose to be here or were you forced to be here?" And he said, "I chose to be here." "But you just said you were subpoenaed."
Yeah. Well, okay. That's fine. We got some contradictory statements there. May not rise to the level of impeachment, but when you ask the police officer, I'm sure he was able to answer yes to the question that he determined the laws applied because you were physically in New York. And real quick, for the 986 number, just hold on till we're done with Mike in New Jersey, and then we'll get you, and then we'll get you up. I don't want to, because it's just too much to deal with right now. I'd rather just focus on the call with Mike. So we'll get to 986. Is that Connecticut? I forget. Anyway, I'm sure he was able to answer that first question that, yes, he determined the laws applied because you were physically in Jersey. When you followed up that with the facts to support that claim, that's when the prosecutor objected, right?
Yes.
Every time. And just for the audience, especially for people who are new, do you remember what that objection was?
I don't remember specifically, but she said, I think she just objected, and that, they work together. So it's like object, sustain almost.
Yeah.
A lot of the time.
Did you ask for a clarification? Why the question was not proper?
I would ask sometimes I would ask a different question or something. I
Well,
didn't
you see,
ask for clarification in that case.
well, these I mentioned that these are the only questions that, especially in situations like this, that we actually need. That when the prosecutor objects to that question for the facts that his claim or his determination was based on, when they object to that, they're cutting right to the heart of their case. And so if they're not going, see, typically what they'll do is they'll say objection calls for a legal conclusion. The witness is not competent to testify. And then we could just point out, I didn't ask him for a legal conclusion. I asked him for the facts, his determination at the stop. And so you can certainly argue that it's a relevant. Even my critic argues or agrees that's a valid, relevant question. They just say you should just throw out Rule 702 allows the witness to answer that question. That's up to, I'm not going to, it's up to you or whoever is in that situation. If you want to first address it's not a proper objection and then throw out, and also Rule 702 allows them to answer the question, even if it's as the prosecutor frames it. So it's important for us to be able to know and have them bring out why that question. So you may say, well, objection. That question went right to prior statement, which just happened. For those listening, new, the question of facts goes right to his prior testimony as to what happened and precipitated the stop, which was his determination. He had jurisdiction to act. And then had probable cause. So it is absolutely relevant and should be allowed. And that not allowing an answer to that question is a constitutional error of the first magnitude, where no amount of showing of want or prejudice would cure it. There's many Supreme Court cases that quote that. So I would say here, if you were inclined to appeal or do a post-conviction relief, denial of effective cross-examination is a pretty good start. It's a pretty good issue.
Okay, yeah, I'm considering appeal. I have to find out the costs.
Yeah, you could do both. You could do the appeal and you could do post-conviction relief. So yes, the post-conviction relief petition, I do have a template for that too. Yes, it goes to the same judge, but it's not in the heat of the moment, so he may see reason.
Yeah, I mean, it was also late at night, so I think everybody wanted to get out. It's one of those things. The judge is hungry. Everybody wants to get out. So
yeah, no doubt.
It's they put you last so to grind you out, and then so they're all tired, and everybody was there. Given that we want to go home face. Why are you doing this to us?
But they're the ones who forced you to be there that late anyway. So who are they to,
I mentioned that to the prosecutor. I said, I'm forced, I'd rather go home. I don't want to be here. And she said, you're not forced to be here. I said, so what happens if I leave? Well, your license could get suspended. And I said, well, there it's forced. And she said, no, it's the DMV. And I said, yeah, it's one bureaucrat passes it to the next. So nobody's really culpable.
Well, the DMV is going to do it based on an order from the judge. The DMV doesn't just, even when you get a DUI, there's an order from the court to suspend the driver's license, like in California, for example. I mean, so there is an order from the court. And the fact is that if you didn't show up last night, they would have issued a warrant for your arrest.
Yeah.
So I would say that just on what you've told me, it sucks that happened. Yeah. But if you have a situation where you've asked a relevant question that goes right to the heart of the prosecution's case, you're asking a question to the police officer for the facts, a prior statement was based on a prior determination. See, it doesn't, and especially when that determination forms the foundation of his case, for you not to get an answer to that, for them to object and not even give you what the objection is. I mean, wow. I mean, the prosecutor didn't even give the standard, just objection, because they didn't like the question. Well, that's not legal grounds to sustain an objection. It's not legal grounds to object. I think on that alone, you've got denial of effective cross. I mean, I'd have to hear the rest, but I think that particular thing, because it sets the relevance for everything else, and they can't prove their case beyond a reasonable doubt unless the police officer testifies to those things. And so here you've got denial of effective cross, denial of a fair trial, and the prosecution did not meet their burden. And that's not even getting into the Brady violation and putting a witness on the stand they knew didn't have personal knowledge.
Yeah, I asked the cop if he knew what a Brady cop was, and he said, "Yeah, I know what it is, but I can't define it." When I asked him to define it,
a Brady cop who's got a history of Brady violations, where they have knowingly, where they've knowingly given false testimony or falsified a record. I mean,
well, they're not used to being challenged, so.
Yeah, on a lot of things, yes. There's certain things that they are used to being challenged on, and there are things that they're not used to being challenged on, and we're coming in and being a bit unorthodox that way. But prosecutors are challenged every day, I'm assuming every day, on Brady violations. I mean, that's a standard defense legal defensive tool is so I take it more that they were just plain stupid or just trying to be difficult with you. I can't define
that's typical.
I mean, there are things that in law are difficult to define. The practice of law, there's no set definition for it. It's just like pornography or something that is offensive. Well, I can't give you an exact definition, but I know it when I see it. It's so with a defining. Look, any half idiot who's gone to law school should be able to tell you what a Brady cop is. They know it. They just don't want to tell you. And they certainly wouldn't want to, especially in California. They want to disclose that information to you. I know a prosecutor. I know a guy who works in Phoenix as a prosecutor, and he's one of the good guys because he says, "No, I have to give Brady. If I have any exculpatory information, I have to hand it over." But not every prosecutor is like that. Most of them tend not to be, according to former Judge Kaczynski. That's why, he said a few years ago, prosecutorial misconduct is at epidemic levels. Because most of them are not like this guy I know. Well, make it, I guess it's up to you if, check out what the cost is. I would say I would at least do a post-conviction relief. So you can email me for that.
Okay. And the cop also, he got the, the location facts completely wrong. He said this occurred at one place. It occurred at another place down the road where he claimed to be was not where he was, and where he claimed I was not where I was. But how do you refute that without testifying?
That's a problem.
I was afraid to consider that, testifying, because that opens me up to any number of questions.
Well, I would say one, was there dash cam video? Did you have a passenger in a car?
No, the police car did have a dash cam, but it conveniently starts after whatever he would have been accusing me of. So it could fit either scenario. And how do you defend against that? It's like if somebody accuses you of a murder and they won't tell you which murder it was.
Well, that's a little different. I mean, in the situation here where I got to tell 986, we're going to get to you in just a second. Just hold up. Call back in a few minutes. And when I finished with Mike from New Jersey, there are going to be situations where unless you take the stand, and look, even if you did take the stand, it's your word against the cop. Who is the judge going to believe? Yeah. Right? I mean,
yeah. Well, it's a toss-up, but by the time the state had rested, I think I had gone through my thing. The impression I got was that I had already lost. So it's almost like you can only go up from there. So I considered it, but it's a stressful situation. So
yeah,
I decided not to. But if I at least cast doubt and make a credible case that it was this, not this. If he can't remember these details, maybe he forgot. Though I don't think he was lying. I think he just saw things.
So he thought it was his testimony conflicted with the ticket?
No. It was the ticket wasn't specific enough to the location of. He said I didn't stop at a stop sign.
Okay.
And the location was a major intersection that has a traffic light, and then there's like side streets that have multiple stop signs. So he didn't specify what it was. He said in court he said that it was coming out of a certain parking lot. I was never in that parking lot. But again, how can I prove that?
Yeah, unless you have a witness and there's some other evidence, because it's almost never worth getting on the stand if it's your word against the cops. You will lose that every time. Yeah. So I'm going to try.
I have seen that work sometimes, where they'll like defer it or something, or put it on probation or something. They say like, well, we're not sure. You do make a credible case that you might have been right, but it's a gamble anyway.
It is.
I have seen that work.
Hey, I had somebody in California do a trial by declaration and won. It wasn't something that I would do. And when people asked me, I said, well, I had one guy was successful. I mean, according to some, I've never had any success, but there is somebody, and it's posted on the website. It was like 3-4 years ago. So it does happen. It's just, hindsight's always 20/20. You can't. Yeah, it's possible, but is that a gamble? Is that a risk you want to take? And and if you're stressed and you're not doing well on cross-examination, how well you think you're going to do on when you testify and you're the one being crossed? So,
yeah, exactly. I mean, I know a little bit how to deal with cross. I've read about that and stuff, but you have to answer. So even if they ask you a question you don't want to answer, she could have asked anything like, were you here or were you there? Say, okay, the laws apply because you were there. I mean, the judge said because you were on the roads of New Jersey, the laws apply. They didn't even say physically in the state, just because you're on the roads.
Yeah. Well, then, if that was true, you should have been able to question the witness on that determination, because the witness is the one the cop is basing his decision on. So I'm going to try to get.
I think that was later on, so I would have to have been recrossed.
Well, bottom line here, I think you got a clear-cut case of a denial of effective cross-examination, because your question was it went right to the facts of a prior statement, so it's definitely relevant. Okay, I'm going to try to get another call. All right.
Yep.
I appreciate it. And contact me off air regarding the template for a petition for post-conviction relief. All right.
Yeah, I will.
All right. Appreciate the call. All right. I know we've got area code 986, and you're just chomping at the bit there. I want to get you on here before we're out of time. So if you just call in again, it's like 8 times now. Oh, there we go. Area code 986. You're live on the No State Project. What's your name? Where are you calling from?
Thomas. I'm calling from Idaho.
I got Idaho. I didn't. What was your name?
Thomas.
Oh, Thomas. What can I do for you today?
Okay, I emailed you yesterday about the 3-hour motion hearing.
I'm still in shock that a motion hearing went 3 hours. My gosh.
Yeah, I can give you some of the points, but I'm going to have to go through that to remember all of it. So I was listening to the other guy, and they brought up judicial notice as well. And I listened to that, not for so you're saying judicial notice is only for law, not legal arguments?
No. Judicial notice, almost across the board, is for adjudicative facts. So they can take judicial notice that you are physically in Idaho. They can't take judicial notice that being physically in Idaho proves the laws apply, because that's a legal conclusion or a legal determination or a legal argument. And legal arguments are not something you take judicial notice of. That's something that has to be proven beyond a reasonable doubt at trial. So if you're in California, they can take judicial notice of what the laws say, not whether they apply to somebody, just what they say. So just like, the Anti-Injunctive Tax Act. They take judicial notice that the Anti-Injunctive Tax Act says that the district courts may, deprive the jurisdiction of any suit to enjoin the collection of a tax. They can't say anything. That's all. They could just say that's what the law says. That's it.
Okay. So I was objecting to motions being denied and some of the previous things being said. He would always yell at me and shut it down, and I couldn't get in a word. Like, the farthest I could get with an objection was objection, point of clarification, or just objection, and he'd yell at me and then shut it down and then continue. And I couldn't, and then if I tried to bring it up again, he'd just yell at me until I was shut down again, so I couldn't get anything other than objection.
I got to tell you, that screams of a violation of the canons of judicial ethics. I mean, he's bullying you and he's yelling at you. At any point did he threaten you with contempt?
No, not at this. At this motion hearing. The motion hearing before this, he did threaten me with contempt for not standing up. But I mean, that's something different. But no, but he would just yell at me until he shut it down, and then he would continue. I could barely get any objections in. At the very end of him wrapping up his section, I did object. I said I object to all of that, just because I couldn't get any objections. And I was like, well, I object to all of this because you're citing, the code says it applies, so it applies. And the whole thing was about the motion hearings. And obviously in the motion, I'm asking why, because of my physical location, does Constitution and codes apply? And I was asking, the prosecution said, that's the basis of his foundational claim. And I'm just wanting, is there any facts on that he's presented to you? And he wouldn't address anything. He just go on rambling about the code, and when I objected, he'd yell me down. And also, they printed off the objection to the motions at the motion hearings. I didn't receive it prior.
You think you can get away with doing that to the prosecutor?
No.
No, hell no. Not at all. Well, did they set this matter for trial?
Yeah, I thought I did have a jury trial in 24th. That got vacated. Now it's February 8th.
Yeah, you're breaking up pretty bad there, Thomas.
I have can you hear me now?
Yeah.
Okay. So I had a jury trial set the 24th of this month, and they had that vacated, and they moved it up to the 28th of February, and I have a it'd be a fifth pre-trial, February 10th.
Wow. If you go right to the Rule 2.3, the Idaho Code of Judicial Conduct, bias, prejudice, and harassment. A judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. But here, subsection B is a big one. A judge shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice or engage in harassment. I think yelling at you and not allowing you to have a say in your own defense, I'm going to go out on a limb here, even though I'm not a lawyer. I'm not even a court employee. Never been to law school, but I can read. I'm going to go out and I'm going to say, yeah, he was harassing you by yelling at you like that. I'm going to, yeah, I would, you could, so the rules that you can file a motion to disqualify or recuse the judge.
Yeah. So yeah, I guess that's what I'll try to keep it quick. So I think for 3 hours, what I can remember, that's mainly what happened. He obviously asked me to argue my motions, and I said, well, I can clarify as the prosecutor presents, overcome them. And then he went to clarification. And apparently, corpus delicti was amended in Idaho, and it doesn't exist anymore. So they said they had subject matter jurisdiction.
Well, it's still an adversary proceeding, and the Supreme Court said that there has to be an antagonistic assertion of rights to be adversarial. So even that's why in my motion I say even if you don't use the phrase corpus delicti, the fact that they're advertising it as a adversary proceeding, you're still supposed to have that. And of course, the violation of the legal right here is supposedly the violation of the code. If you go back into the section Rule 2.6. A judge shall accord to every person who has a legal interest in a proceeding the right to be heard. And here he's yelling at you and not allowing you to voice an objection, basically yelling to intimidate you into not objecting. I can see if your objections had no basis. Of course. He doesn't have to yell at you.
Yeah. Okay, so what motion? Obviously disqualified the judge. He denied all of my motions, obviously. Granted all the prosecution. So the motions that were denied were the original motion to dismiss for full finding and exclusion of fact law, then prosecutorial motion to dismiss for prosecutorial misconduct, and then motion to eliminate. And I objected to all of that being denied, but he let me shut it down.
Well, what we wanted to do, I'm sorry.
File, obviously.
Well, I would file to recuse the judge and then have my motions, a motion to reconsider my motions because they were denied arbitrarily. Yeah. And in the grounds, what I laid out for you, the grounds would be because the bias is, the bias, but you also have that he's harassing you. The guy's yelling at you. And that is bullying you and intimidating you into not voicing an objection.
Yeah. And I don't know. I mean, it obviously doesn't mean too much because it's not a fact. But he did say that they are getting personal jurisdiction when the officer gives me the complaint. They specifically stated that. And
okay.
Some of the prosecution was objecting also to some of the cited cases in there, saying there was bad ratings on them. So should I be more careful what cases I cite and look up the ratings before? I mean, obviously I probably should, but I mean,
the rating of the case.
Yeah. I guess there's ratings and there's bad ratings on these case sightings.
As long as it's current and the rule, like the case hasn't been completely overturned or it hasn't been modified, then it's a primary source. So there's Supreme Court cases there, so as long as the Supreme Court hasn't reversed or modified their own decision, and I don't think the Supreme Court's going to come out and let's say, we were wrong about what an adversary system is. We were wrong. It doesn't require an antagonistic assertion of rights. Well, we were wrong. I can't, even if on the civil side, we're just talking about the doctrine of standing, they're not overturning that. So I would have just said, what are you, is the prosecution saying that the cases aren't relevant case law, that they're not current law? What are you rating? What then? It doesn't have 5 stars. What the hell is? That's why
I didn't object to that. I wasn't expecting that. I had no clue what to say that. I was just expecting. Well, I still haven't, seen any facts. Is there any facts on record? I had no idea how to respond to that.
Well, I get that is a new one. To say it's the rating. I was objection. What are you trying to say? It's not 5 stars. I mean, or is this? Are you saying it's not current law? Are you saying they're outdated?
Okay. Yeah. So reconsider. I was also thinking about a writ of mandamus. Would that? Because I'm thinking of trying to throw everything I possibly can at them.
Well. What are you gonna use the mandamus to force? What order do you want forcing the judge to do? I mean, what are you trying to force him to do?
well, let me object and then hold the prosecutor to their burden of proof, because the judge wasn't. He was up there reading off codes and citations that were in the prosecutor's favor the entire time. And when he was reading off codes and citations and case law that were, going against mine the entire time, there was very clear bias that, if you...
Well, that's not what a mandamus...
go back and see the recording.
No, that's not. A mandamus is not for that. The mandamus is to force an officer to do a mandatory function of the office. So the judge, it has to be a mandatory function, and it's extremely difficult for little people like us to maintain a petition for writ of mandamus. The only chance that I've ever had, and I've done this at the state level a bunch of times, never at the federal level, whole different story there. You file the motion to recuse the judge first. If it's denied, then you have solid legal grounds to do the petition for writ of mandamus, to have the appellate court review it. And if they agree with you, then they will order the judge to recuse themselves. But that's the main reason why I used the motion to disqualify the judge, because if it's denied, I can stop the trial on the petition for the writ.
Okay. I mean, that's really all I can remember at this point. Obviously, it was 3 hours I have to go through this entire thing. But, yeah, I'll get that reconsideration and motion to disqualify.
I have a template for that, so just email me after the show.
Okay, will do.
All right. Appreciate the call.
Thank you.
That is insane to have a 3-hour motion hearing. Wow. That's a lot of yelling. That's an awful lot of yelling, I'm sure, for that judge. You're probably more hoarse than I am right now. Gee. Well, hey, we got through it. It wasn't too bad using just Skype. I'm gonna end the show here in a couple of minutes. So we were able to do that. Somebody mentioned something about would it be worth doing an affidavit of showing that you're stressed. I don't think that would help at all. They don't care that you're under threat, duress, and coercion. They don't give a damn. They don't care. It's not gonna, and I don't think it's gonna change. It's not like it's an issue we can take up on appeal that'll be taken seriously. I don't think it's worth doing. I make it a part of the record. I don't need to do an affidavit. I like when they turn around. Who's forcing you to do anything? If I didn't show up today, what would you have done? Well, I'd issue a warrant for your arrest. Bingo. You're the guy who's forcing me to do it. You're the one who's causing me stress. You're the one who's imposing the coercion and the duress, the threat, duress, and coercion. Hey, but that's not going to help us. You can sign your ticket. TDC. Whatever. They already know you don't have a choice. They don't care. All right, yeah, I'll do the Discord thing. Maybe we can use Discord next time. But then someone's saying you can't use Discord and Skype at the same time. I don't know how that's going to always work out. I probably more people are able to call just using the regular line. I will do that. I will do that after the show. But good. At least, hey, we had some bad news, unfortunately, what's going on with Mike in New Jersey and Thomas in Idaho. That's unfortunate. We had someone in New York did get a ticket tossed out, which is great. And we got 2 stays from the IRS just today. So we're off to a pretty decent start. And if you would like to support the show, and I do appreciate all the support, guys, I do, you could do that at markstevens.net and markstevens.cells.com. And if you are being attacked by a bureaucrat and you want to learn how to more effectively defend yourself, then markstevens.net. Check out the government indicted, as well as the articles, and we have scripts and we have templates. I think somebody was asking if I had a tax template. I do. But you'll notice that if you get one of the scripts that's got a whole lot more than you'll hear me say on a call, because it's more to address, to train you to focus on what's important, what the objective is, and how to get there, and how to stay focused, keeping them focused on what the, like, I had an IRS agent today. She says, can you just answer yes or no? I said, I can't answer yes or no, because you're peppering your question with so many legal terms, and I don't think you understand the implications. So if I just answer yes, you're accepting those, or your lawyers will accept those legal terms and the implications behind it. Now, whether someone's a taxpayer or not is not a statement of fact. That's a legal conclusion. Okay, that's a legal claim. Just like if someone is a resident. That's a legal claim, not a statement of fact. And I said, if I will answer yes or no, if you stop peppering your question with loaded words. Use lay terms and we can have a conversation, yes or no. But if you insist on throwing in legal claims, I have to expand my answer. So I'll say yes, but I have to explain every little thing. I know what it's like not to get yes or no. Yeah, but I don't pepper my questions with legal terms in order to, get you. So anyway, I think we covered a lot of good ground here today for January 15th, 2020. And I will do what I can to fix the caller line, because it worked pretty good here today, but I'd rather have it the way it was. It was a lot easier. So, but I'll get that straightened out. But hey, till we are live again on the Saturday show, salud.